Welcome to panel 5. I'm delighted to be chairing the stage with 4 eminent experts to debate questions of jurisdiction and complementarity. The Lubanga trial chamber, in a 2006 decision, described the concept of complementarity as one of the cornerstones of the statute. This panel is dedicated to exploring whether this cornerstone is load-bearing. For the uninitiated among us, Article 17 of the Rome Statute is the core of this cornerstone. It sets out issues of admissibility and provides that the OTP of the ICC cannot investigate or prosecute a given case unless the state that has jurisdiction over this case is either unwilling or unable to genuinely carry out the investigation or prosecution. This provision was, in many respects, an ingenious compromise solution that ensured that the Rome Conference did not become a failed example of international bargaining, of which there are many. It also ensured in practice that the imperative of cooperation continuously looms large over the ICC, and even larger than it did for the ICTY and ICTR. In preparing for this panel, I was reminded of a frank little book by Richard Goldstone, For Humanity, in which he reflected on his work as the first prosecutor of the ICTY and ICTR. And what always stuck in my mind is Goldstone's recollection of what it took to cajole great powers and minor ones to cooperate with his office. It was hard work, as many of you in the room can attest to personally. For reasons that were alluded to yesterday, the imperative of ensuring cooperation with states is even greater for cash-strapped ICC. It has meant that some of its prosecutors had to retool as diplomats. And whatever you think of the first prosecutor of the ICC, he does deserve credit for the invention of the JCCD, the Jurisdiction, Complementarity, and Cooperation Division. In the early institutional designs for the OTP, no such unit was contemplated. And here with us today is the ICC's longest-standing diplomat, Phakiso Mochochoko, the director of the OTP's JCCD. Phakiso, in addition to heading since 2011 this JCCD, the diplomatic wing of the OTP, if you will, you chaired at the Rome Conference the Working Group on International Cooperation and Judicial Assistance, which drafted Part 9 of the Rome Statute. Phakiso, take us back to Rome. Give us a feel for some of the contentious issues pertaining to international cooperation that divided or united states that came together 20 years ago. And did anyone at that time foresee that Article 17 would pan out in the real world the way it has?
Thank you very much. Thank you very much, Jens. Everybody has thanked Klaus for the sterling work that he's doing for the Academy. My recollection of my last being in this room was when we were discussing the infancy of the Academy itself to see exactly how it would work. And it is great that today we are here gathered in this room again on something that is now practical. I think like the ICC, the Academy has gone from being just an idea on paper to something that is now live. I'm not surprised at what everybody has said about Klaus. I mean, personally knowing him, Klaus and I go a very long way back when I was tasked with the unenviable task of going to the Hague in July 2002 and opening the doors for the ICC, thanks to Philip Kish and all the other founders. One of the things that I had to do was to find a lawyer with IT technology And Sam and I said, where on earth do we find such a person? And looking around, Hans-Peter Kaul, late Hans-Peter Kaul, said, I have somebody like that. I said, who is that? And he said, no, it is Klaus Rakwitz. And I again had an enviable task of contacting Klaus to convince him to come to the ICC. And Sam Muller told me, Phakiso, you cannot fail on this one. We need this person. And that's when our relationship with Klaus started. When I first met Klaus, we were supposed to meet in Strasbourg. I didn't know him, he didn't know me. And I was in my hotel room, we arrived there, and I said, Klaus, are you here? He said, yes, I'm here. I said, how do I identify you? He said, come down the lobby, you can't miss me. And indeed. And I went downstairs. And those were the good old days when I still had my hair. Klaus can testify to that. Yes, and photos of that. I mean, Rome, for the founding mothers and the founding fathers here, was an experience on its own. And I think in the first session, some of these issues were quite elaborated upon as exactly how we were in Rome. Cooperation, the cooperation section that I headed in Rome under the leadership of Philip, it wasn't much of the most controversial issues, really. There were much more difficult issues that we dealt with in cooperation than cooperation. One of the most difficult issues that we had to deal with was whether there could be any refusal by a state to cooperate. And indeed, taking into account what you have in mutual legal assistance agreements as well as in extradition treaties, where there are grounds for refusal to cooperate. The question was whether in the ICC we could have those grounds of refusal to cooperate. And after lengthy discussions, it was clear that now there can be no refusal to cooperate, that the obligation to cooperate transcends everything else, and that no state can ever refuse to cooperate. As has been now widely accepted that complementarity and cooperation form the core of the ICC work, and that without complementarity and without cooperation, then you cannot have ICC work, the ICC work carry out its work successfully. One other provision in the context of what was going on in Rome was, of course, the now notorious Article 98. And I'm looking at David Schaefer here, who gave me sleepless nights over the negotiation of Article 98. Article 98 in itself, again, was trying to find a compromise, really, of how can we be able to work out the relationships that states had with each other, diplomatic relations that states had with each other. The way that it was conceived, at least in my view and in my recollection, it was never intended for any future agreements that were intended, it was intended to cover previous agreements that had been entered that would make states violate its obligations under its international obligations. All in all, as I say, the provisions on cooperation, the methods of cooperation, how the states should cooperate, clearly defining what the states shall and can do to cooperate with the court, those were clearly spelled out. The list of the mechanisms or the ways in which the state can cooperate is a non-exhaustive one. Again, that was deliberate. Even much as we tried to be as elaborate as possible, it was also seen that you cannot be exhaustive in any way in providing the mechanisms and the ways in which the court can coordinate, the states can coordinate. So that list, it was just merely an indicative list, and that there could be many other ways by which state could cooperate with the court. Talking of complementarity, just briefly touch on that. I think I'm sure that we'll be able to come to this later on. Amongst the mothers and the fathers here, can anyone tell me where do you find the concept complementarity in the statute or in any of the framework documents of the court? The term complementarity. It's nowhere. Don't find complement. Unlike any other concepts, admissibility, nes bis in idem, whatever you call it, you don't find complementarity anywhere in the statute. And that may explain why we are still grappling with this issue of complementarity now, what it means. David Tolbert, through the green tree, you try to find out what complementarity is. The EU came up with what is called the complementarity toolkit. Up until now, I don't know what happened to that. The ASP, even now, is still trying to talk about complementarity. So I think it is important that we, today here, I'm yet to see, at least as a practitioner, as one working for the ICC and the Office of the Prosecutor, I'm yet to see anything really concrete about complementarity. The way that it was conceived in the statute, the way that states themselves conceived it, that states should be the first bulwark against impunity.
Because if I may jump in, what's interesting here is the OTP, you're absolutely right, complementarity isn't in the statute, but the OTP has sort of jumped into the breach very quickly and coined this phrase, invented the idea of positive complementarity, right? And that's related to the idea of self-referrals to initially get cases. Now, some have suggested that this kind of way of getting cases to the court is just a juvenile phase of the ICC, that the OTP also may grow out of. Like, what you make of this relationship with states? You've received a fair amount of criticism for these so-called self-referrals as well. I wonder if you could reflect on the practice of making this complementary regime work and how your office in particular has sort of led the charge, if you will, to fill this vacuum that the drafters at Rome left. Yeah. I mean, the whole concept of self-referral, I don't think that anyone who is here now, who was in Roma, ever conceived of self-referrals. The concept of self-referral was never. The idea was that states themselves, in protection of their own sovereign right, states, because they had been afraid of this extraterritorial institution that would investigate and prosecute their own citizens, they wanted to retain the right themselves to investigate and prosecute this. That is why, in addition to Article 17, you have this basically in the preamble of the statute, where it clearly says that, recalling that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. And then the other part is emphasizing that the International Criminal Court established under this statute shall be complementary to national criminal jurisdictions. So it was always the intention for the states now to protect their own sovereignty. The ICC was never intended to be a court of first jurisdiction. It was never intended to be a court that replaces national judicial systems. It was intended to be complementary to national judicial systems. One of your questions that you posed us was, what is the role of national judicial systems in complementing the ICC? It's not that way. It is the ICC that is supposed to complement national judicial systems, not the national judicial systems complementing the ICC. So I think it was this realization at the very early stages of the OTP and conceiving the OTP that this concept was realized as very crucial to the work of the ICC, that the first and foremost, the primary responsibility to investigate and prosecute these crimes lies with the state themselves. Unfortunately, as it turns out that now, the wrong questions are being asked now. Whenever you have got commission of crimes anywhere else now, the question that is being asked is, what is the ICC doing about this? The question should be, what are the states doing about this? And it is only if those states are either unwilling or unable to genuinely investigate that the ICC should come in. And that is where the concept of complementarity comes in, and what is we still need to understand. I've had some discussions in some states now, they say, where's complementarity? Where does it come from? It's not even in the statute. It's a figment of the imagination of the previous prosecutor. What is positive complementarity? What do you want to do with this positive complementarity? We don't even know what it is. So we still seem to be quite a long way from understanding what complementarity is and how it should work in practice. David and I in the past, when he was
in the Green Tree context, we have tried to really formulate this now. The EU toolkit on complementarity, try to really thresh out this now connotation of complementarity and how exactly it is going to work. We are yet to see a situation where the ICC is prevented or the OTP is prevented from investigating because national judicial systems are doing what they are supposed to be doing in the first place. Or at least, even in the reverse, that they do what later on, if the OTP focuses on those who bear the greatest responsibility, then the national judicial systems do take over that the other, because of course the OTP cannot do everything. Maybe in Uganda and maybe in the Central African Republic, those are, we can see that, but we are yet to see such situations where complementarity, as was foreseen in the statute, has actually been implemented in practice.
Okay, thank you, Phakiso. I'm sure there's questions from the audience we can turn to later on. Let me now switch to Brenda. Brenda Hollis has worked in many empirical settings, from Sierra Leone, where she spent most of her time at the helm of the Special Courts OTP, but also in Iraq, Indonesia, Cambodia, the DRC, and Colombia. Brenda, let me ask you, switching from complementarity to cooperation more generally, would the creation of 25 ICC country offices do the trick of legitimating the court and to facilitating more cooperation? Bill Pace made the suggestion yesterday, and he thought it might do the trick to create these country offices. And after all, if there's anything in the international community, especially the UN system, is good at, it's good at setting up country offices. So I wonder if you, based on your extensive experience, could reflect on this proposal. Would this make a difference to ensuring continuous or more cooperation in the future?
Thank you for that question. I think it's a good idea, either country offices or perhaps regional offices. And I think it's a good idea based on my experience first with the ICTY and later with the Special Court for Sierra Leone. When I was at the ICTY from 1994 until 2001, we really had no outreach program to speak of. We certainly didn't have an effective outreach program. And we were only dealing with one country. As a result, we were unable to manage the expectations of the population as to what a judicial institution can really do and cannot do. And I think the resulting dissatisfaction was in large part because we were unable to interact with them and have a dialogue with them on a continuing basis about what we were doing and what we were unable to do. In contrast, in Sierra Leone, we had a very, very effective outreach program. From the beginning, it was a dialogue, and the people of Sierra Leone overwhelmingly supported the work of the court and saw the court as a positive factor in ensuring a sustainable peace. So I think the creation of these offices for the ICC, certainly I can't say would ensure cooperation because I'm not sure anything can ensure it, but it would facilitate more cooperation. It's not just because these people in these areas are the major stakeholders in the proceedings, but it also facilitates, I think, the achievement of the judicial mandate of the court. Because when the people know who you are, when they have human faces to put with an institution, when they understand what your mandate is and how you're carrying it out, they're more willing to come forward with information that is relevant to you, either for the prosecution or for the defense. So I think it's a very good idea. I think that in addition to that idea, it would be very good for the court, which like all of the courts has financial challenges, to have regional rosters of experts that they could call upon when they have situations in the region. People who speak the language, understand the culture, but also have the requisite experience and skills. They could supplement the court, and I think that would be to the benefit of a court with a limited budget.
Thank you, Brenda. Could I follow up on this suggestion? So how do you see this operating in practice? Do you see the OTP hiring these experts as consultants on an ad hoc basis? Would they be permanently associated with the OTP? How could you make this work? Because you've been on the inside of two courts as well. How could this be done in practice?
I think you would have to have them on some sort of short-term or consultancy contract. I think you would require a commitment from them, or better yet, a commitment from states to offer you very skilled and experienced professionals to assist the court when needed. And so there would have to be a guarantee of availability when needed. But if you had a roster, you could go down the line if someone was not available. And it would benefit the court because when you didn't need them anymore, you would not be paying them as a permanent staff member. So you could focus more on a permanent staff that had oversight responsibilities, that had overall expertise in the functioning of your organ of the court.
Interesting. One more question for you, Brenda. The complementarity regime, whatever we think of it, is here to stay. Do you have any additional ideas for improving it? And do you have any specific advice for Phakiso as a fellow prosecutor?
Well, I certainly am present an outsider's view of the court. I've never worked at the court, so these are purely my reflections looking at the statute and looking at the jurisprudence that has developed. I think this word complementarity was actually derived from what Phakiso has referred to as the fact that the ICC will be complementary to national criminal jurisdictions. Perhaps it never should have been coined because I think it's led to a lot of confusion. I think that the principle has to be developed because some of the operative language and relevant provisions is, in my mind, unclear. And I'm referring specifically to Article 17, but also to Article 20, subparagraph 3. When we look at Article 17A, they talk about the case being investigated. They mention nothing about crimes under the jurisdiction of the court. They talk about the case. When we look at Article 17C, the language is, the person concerned has already been tried for conduct, which is the subject of the complaint. Well, what's the complaint? What conduct are they referring to? What is meant by case? How is it defined? What is meant by conduct? How is it defined? In Article 23, we have a provision that prohibits the ICC from proceeding when there has been a trial for, quote, conduct also prescribed under Articles 6, 7, and 8 of the statute. What does that mean, conduct prescribed? Because of these ambiguities or this unclear language, it challenges the court because the court has to interpret this unclear language. The court has done so, as it must do, in order to rule on issues of admissibility. And the court's response to this challenge, their opportunity to excel, appears to lead to the conclusion that, at least in terms of the judge's opinion of the resolution of this ambiguity, the real issue is not the legal characterization of the conduct as international crimes, but rather the court looks at the overlap required between incidents, and this is a new word. What does incidents mean? Between the incidents being investigated and those being investigated by the state, with the focus being upon whether the conduct is substantially the same. What do we mean by conduct being substantially the same? But then the jurisprudence seems to go on to say there is no requirement in the statute for a crime to be prosecuted as an international crime domestically. But is this interpretation by the court consistent with other relevant statutory provisions? Is it consistent with the intent of the statute? Why are these questions important? I think they're important because, first of all, the court must effectively and accurately implement the provisions of the statute and must act in accord with the intent of the statute when they're determining admissibility. And it's also important for the ICC because, as I understand it, of the 123 states parties, over 50 have not domesticated in any way the crimes or acts in the Rome Statute. And of the some 71 or 72 who have domesticated the crimes and or acts in whole or in part, this must be, as I've been told, must be treated with caution because they may define the crimes or the acts differently, and as they say, they may have not domesticated any or all of the international crimes. They may only have domesticated some of the underlying acts. And it's also important because the answer to these questions informs what we mean, what is meant in the statute by the language in the preamble and in Article 1 that says the ICC is complementary to national criminal jurisdictions. Does it mean that they are complementary to these national criminal jurisdictions when they are exercising that jurisdiction over international crimes? Or is it satisfied if they are exercising that jurisdiction only over domestic crimes, even when there's evidence that international crimes have been committed? The answer is important because if we take the latter answer, that would mean that a state party that has not domesticated any of the crimes or the acts in the Rome Statute could be found to be in compliance with complementarity and could challenge admissibility if it is prosecuting a situation or prosecuting conduct as purely domestic crimes, even where there is sufficient evidence to indicate international crimes have been committed. My review of the statute and also of the prosecutor's policy paper on preliminary examination leads me to conclude that the court's interpretation is not consistent, does not reconcile this unclear language with other provisions in the statute, and is not consistent with the intent of the statute. I am of the view that the proper interpretation of these ambiguous terms leads us to the conclusion that the only instance in which the legal characterization of the conduct does not matter is where the state is legally characterizing it as one international crime, whereas the prosecution or the court may legally characterize it as another. But where the state is legally characterizing it only as a domestic crime, I think this distinction, this legal characterization does matter. And my conclusion is really based on looking at the plain language of the preamble and other provisions. So in the preamble, they have the ICC statute affirming that the most serious crimes of concern to the international community must not go unpunished, and their effective prosecution must be ensured by taking measures at the national level. We're talking about international crimes here. And they also recall, as Phakiso mentioned, that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. In addition to that, I think Article 18 is informative when it talks about the notice that the prosecution must give, and it, in subparagraph 2, it indicates that the state may inform the court it is investigating or has investigated with respect to criminal acts which may constitute crimes referred to in Article 5. I think this clearly indicates that the obligation of states is to exercise its national criminal jurisdiction to prosecute international crimes, not to characterize them or to prosecute only them as domestic crimes. So I think this is a problem. I think it needs to be corrected in the court. I think the effect of the court's current position is to impose limitations on the exercise of the court's jurisdiction, which are not consistent with the intent of the statute or with the clear language of some of the provisions of the statute.
All right, thank you, Brenda. You've given us a lot to think over. While you do, let me turn to, from the international side to the domestic side. We have two prosecutors who have garnered a great deal of experiences in various domestic jurisdictions. We have, I don't think you mind if I call you this, an activist lawyer, and we have a federal prosecutor. Let me start with Almudena. You in particular have a great deal of experience in making domestic investigations and prosecutions work, especially in Latin America. Let me ask you, in light of the various challenges we've been discussing these past days for the ICC, is the arc of international justice bending back to the local?
If I may, I also would like to thank the Academy, just 1 second, and Mr. Klaus. It's my first time in Nuremberg, so it's particularly, I suppose, moving for me because of the trials and all of us in these professions, but also I think there is a critical challenge in history, a critical moment, I would say, for the ICC, and I think inviting national practitioners doing extraterritorial legal battles is the beginning of the change. I've learned quite a bit in the last few days about the court and about the many challenges, as I said, that there's facing, and it's been a great experience. To your question, James, I just, feel that it's, for 20 years, actually, ironically, and I was asked by some people in the audience to mention, I think it's very important, ironically, we are celebrating simultaneously with the 20th anniversary of the court, just this week, also the 20th anniversary of the issuance of the arrest warrants that put Augusto Pinochet, dictator of Chile, in a UK jail. And I think that it's important how that was definitely the best summer of my life, as the Rome Statute was signed, and then Pinochet was arrested. But I think that we saw a trend, coincidentally and historically, only we humans do that. We saw a trend starting at an international level with the ICC, and at the national level in so many countries, and of course we'll have the pleasure to listen later to Germany, so many countries happening as well, and everybody was assuming in that moment of collective, I don't want to call it euphoria, I think collective responsibility, that it was enough. And the weather went from the past with retrospective jurisdiction, or you want to call it, or the future with the establishment of the ICC. We needed to take responsibility. I don't think we are in those days anymore. It's a huge backlash that we hopefully are going to fix. But just to your question, and I think it's very interesting, and interrupt me or focus me, because I tend to speak in circles. I think there's a lot of the things that I listen to these during these days, and we're talking, and I completely agree with Brenda about the lack of definition in a much deeper and wider scope of that complementarity will mean. I feel that the core has internalized some sense of being subsidiary more than of being complementary. And I think that is a little bit of a stigma that I would like to see removed. It maybe might be by the jurisprudence of a more open interpretation. In a way, in Latin America, everything is not being hunky-dory. Quite the opposite. The countries, in a way, universal jurisdiction, and now not anymore universal jurisdiction, because it doesn't really exist as such. We have different levels of extraterritorial jurisdiction, but we have come to destroy, fundamentally, that idea that states can, under the Convention Against Torture, just go only and exclusively because of the nature of the crime. Now we have invented passive personality, active personality, and some many jurisdictional requirements. But that aside, it's also been an evolution, and I wonder how much of that experience could be helpful to the involvement and the challenges that the OTP is facing. If I were to be the boss of the world, which I like, I will say a lot. I think that a lot of the, if you allow me, and respectfully, but a lot of the complaints and the whining of the challenges that the OTP faces, so that the court has been present in all of our litigation in a third country. I think that we had, from standing issues to evidentiary issues to challenges of authority to antagonisms that happened to be expressed politically with very nationalistic arguments that it's my criminal, it's my justice, setting aside the victims and the needs of the victims. And they also will learn, if I may, because today is about complementarity, we also learn when a country was not was not unwilling anymore to pursue justice. It was just simply unable. They had national statute of limitations running. They had divisions amongst the prosecutorial units, including courts, and then how it was a fascinating evolution. I'm still going through some of those cases and phases in which we learn how to work with those who were sympathetic to the idea of a prosecution happening abroad that could have a positive impact in the home country. And something that I wanted to say in relation to the panel before, and I was the last question and they didn't take my question. They was also learning how to, as counsel for the victims or as counsel, they will have a special something to bring to the case or even initiate in these cases. We've learned in a hard way, and a little by little, and it was hard for everybody, how to gain the trust of the prosecutorial units, how they will realize that what we can bring is rigorous and is professional, and it's a wider scope of the facts, the truth, the evidence that can be presented. And I think that that's been a huge change in mentality and for all of us, and everybody has contributed to these cases successfully, I will say. And then now, more specifically to your question, I do not think that I'm a humongous defender and very intense one of the ICC. I think it should coexist, but I think that there are new challenges that also come from attempts, and I think Brenda has touched on something very dangerous, at least in Latin America. Everybody has now acquired a language of transitional justice and accountability, and I think everybody thinks that they even new governments or governments that we know may be a little fishy has an agenda on truth and justice, and they put those words and they think that they gain trust and blessing from the international community. And it's a lot of fraudulent, I don't know what the word will be, mocking. It's a lot of countries that have crimes against humanity only naming a constitution, and they think that with that they have already implemented sufficiently the Rome Statute, and that they should be let alone because nothing is going to happen, and that their victims, their courts, and the prosecutors are complicit to not really move in these cases. So I think that it has gone nationally out of a little bit of lack of resource, whatever it is, a little bit of frustration. It has gone nationally because countries have evolved, generally speaking, on a human rights agenda, but I think there's a lot of dangers in that process that make even more poignant to me to have a very strong and clear complementarity, a very strong and clear international criminal court.
Okay. I wonder if we could become more concrete now. If I understand you correctly, what you're saying sort of underneath of things reminded me of something that Brenda told us a moment ago. So in making this cooperation perhaps work between domestic prosecutors and international ones, you seem to be saying that regional, local expertise would arguably make it easier for the ICC to reach into conflicts farther afield. Brenda suggested country regional offices along Bill Pace's suggestion might be one way of getting there. I know that you have some ideas also about creating tighter bonds between the kinds of things that you do and people like you do and the ICC. What are some of these ideas?
Well, just to only speak, which I think is prudent of what I know, as I said, it's not always easy. So for us we were the lawyers working in the communities or with the communities. It's a process to gain the trust. It's not that just because I speak Spanish, believe me, because I'm from Spain. In Latin America, that was another layer of complication. So So you have to gain the trust of the community, and then, but you work with them. You're more present. That's one of the ideas. Then you understand also. I'm sorry to use the word political, because I think that we wanted to try to keep it very, practical and very legal. But there are political implications that nobody can deny. There are divisions amongst the community, whether it's civil society institutions. And then you need to understand them. You cannot assume that by being in one side or another, you have to maneuver. So when you have done all that work, then you have a prosecutorial unit who has mandates on confidentiality, on what we call in the United States, with all the respect to some former Department of Justice prosecutors, the information goes one way. Give me everything you have, and I'm not going to share with you what I'm doing with it. But you have to learn how to. The word is not learning. They then realize that the agenda is only one, and it's common. But I think it takes respect from both sides. That their case is more complete if you have that kind of information. If you guys remember in the last 24 hours, OTP members and people who know way better than I will ever be, the ICC and the challenges of the ICC keep identifying field work, keep identifying, the ability to keep a permanent relationship. Fabrizio said yesterday, 7 years without showing up. Where are the witnesses that I need? All of those challenges can be overcome if there is a closer relationship with practitioners or victims representatives, just to acquire some of the proposals of the last panel, in this more active relationship. And as I said, I think it's a cultural change from how prosecutors are usually built and educated professionally. But I think when you talk about international human rights violations, international crimes to be more precise, I don't think there's another way around. I think that the challenges of investigating these human kind of experiences, these massive crimes, not in quantity but also in impact and in consequences, it will demand that kind of more fluid and circular. And I certainly think that we're going to see very interesting things as Latin America with Venezuela and Nicaragua and other countries. We don't know what's going to happen, but it's going to represent challenges for the court. And the lack of expertise in the court, I think, is probably going to need to rely some of that. So I'm proposing to treat, maybe I'm a big one, I am definitely pretentious, but I'm hoping to treat the OTP the way I have treated prosecutorial units in other countries. I think they deserve the same, obviously, respect and treatment, but just also gain their respect or their trust in how much their investigations will be much better and much stronger if they do.
Mm-hmm. I will push you in a moment a little bit further on this, and before I do, you can maybe think about Venezuela and Colombia, perhaps as two instances which might enable our audience to picture what exactly you have in mind, how specifically these cooperations might take place with Phakiso's unit or other units within the OTP. But before I come back to you, let me bring in Christian into the conversation as well, which is now a conversation about contending fora for international justice. And Christian has a lot of experience here in Germany as a federal prosecutor. Christian, sort of what are your reflections on the kinds of questions we have been talking about so far, and your own work in Germany domestically prosecuting international crimes?
Thank you, Jens, for this question. And first of all, I'd like to thank the Academy, foremost Klaus Rackwitz and Viviane Dittrich, for this very interesting conference today and yesterday. That's a great experience for me as well as a national prosecutor to get in contact again with all the colleagues all over the world and to exchange information and experiences, best practices. I appreciate that really. Yes, Jens, thank you for your question. Well, from my perspective, I think, most important thing is just to do it. In 2002, the German Code of Crimes Against International German Code of Crimes Against International Law came into action almost the same day like the ICC's Rome Statute, one day before, because Germany didn't want to be unable or unwilling, even for one day. Yes, that's the reason why. And from that day on, the Office of the Federal Public Prosecutor General became the only law enforcement authority in Germany what is competent for the prosecution of international war crimes. So we have one office what is competent for the whole country. To be honest, in the first years, almost nothing happened. And we started pretty slowly. And I remember I was in a completely different department of the office, but one of my colleagues was the competent one for international war crimes, one person. Up to now, we are 11 of us only dealing with international war crimes. I switched to this field in 2007. And in 2009, the first unit started at the office consisting of three people. My boss, Federal Public Prosecutor Thomas Beck, who is now the boss of the Counterterrorism Department, and myself and one colleague. And well, it developed pretty quickly. And we had some cases in the beginning. We had some old cases concerning Rwanda, so-called old cases, because we have to deal this with old law before the German Code of Crimes Against International Law, and some new cases, foremost the DRC case against Ignaz Movanashaka and Stratan Musoni. Maybe you have heard about that. This was the case against the two leaders of the FDLR. A militia coming from Rwanda in the aftermath of the genocide, and created kind of a state within the state in the Kivu provinces of the DRC and terrorized the population there. And these two leaders of FDLR lived in Germany for several years. They came to Germany as students, and later on they became the leaders of FDLR because they were not involved into the genocide of 1994 because they were in Germany. And this seemed to be politically opportune to have leaders on the top of the list of this militia who were not involved in the genocide. Anyway, we made an investigation because we got strong indications that both were involved in the current ongoing civil war in Eastern DRC. Started a real investigation with huge effort. We had, of course, we had not only to make investigations within Europe or Germany or wherever, but to go to DRC as well, what was pretty new for us. We've been to Rwanda before in a 1994 genocide case, but then we had to go to the DRC as well. There was no experience with this country coming from German prosecutors. We had to go there and had to start right from the beginning, and we had to do that, of course, everything we had to do on the basis of mutual legal assistance. So DRC, as the host country, had to consent with this, what was not easy to get. As you can imagine, the way between Kinshasa and the Kivu provinces is very far, and there's almost no infrastructure in between. But at the end, we succeeded, and we were able to interview people from DRC, foremost victim witnesses, female witnesses, what was for our office a new challenge, because my office, the Office of the Federal Public Prosecutor, what is the only prosecutorial agency on the federal level in Germany, is only dealing with state security crimes, that means counterterrorism and espionage, and we had no experience with sexual violence, for example, in the office. So we gathered a team of female prosecutors who were experienced, came from local prosecutorial agencies and were involved in sexual violence offenses and were experienced in this kind of crime in order to make the investigations, in order to interview female victim witnesses who were normally, yeah, Philip, you know that, victims of rape, mass rape, and things like that. Well, at the end of the day, after several years of investigation, in this case, we made the indictment to the higher regional court in Stuttgart. Just to tell you, in Germany, the system is that way that the prosecutorial agency of the Federal Republic is only one that is located in Karlsruhe, where the Supreme Court is located as well. But in first instance, we go to regional higher courts. And that means to this regional higher court where the crime occurred, what does not happen in international court crimes, I'm happy to say that, or where the defendant is living. And so that means, for example, in Baden-Württemberg, in the state of Baden-Württemberg, it's Stuttgart, and in Bavaria, it's Munich, and in Hesse, it's Frankfurt, for example. So we went to Stuttgart because the defendants both lived in Baden-Württemberg, and we had a trial of 4.5 years. That is pretty similar to the ICC. And finally, we got the verdict. What was not satisfying in any way, but both were convicted. And for membership in a terrorist organization, this is something I will tell you later on, and at least Ignaz Mochochoko for war crimes. On 31st of October, that means in 2 weeks, we have the appeals trial in the Supreme Court. This is the first, and what was barely the first experience with a German code of crimes against international law, and it was a huge one. Now we, with the incoming of refugees and with the so-called Arab Spring and the crisis in the war in Syria and Iraq, the focus shifted towards the Near and Middle East, and we have currently we are conducting about 80 investigations against known and unknown defendants, alleged perpetrators, about half of them coming from this region of the world. This is for the first.
Thank you, Christian. Very briefly, making sort of bringing it back to the international. We've talked briefly beforehand. If you can just sketch in a few sentences your day-to-day operations and contact with the OTP, with the ICC as well, to understand that level of cooperation between domestic prosecutors' offices and that in The Hague.
Thank you. That's important, and this is why I mentioned the Mochochoko case. As you probably know, the ICC has a situation on the DRC, or several situations, and therefore we had several conferences with OTP, especially with Pascal Tourlon, head of the Judicial Cooperation at the OTP of the ICC, in order to discuss not to do double jeopardy, not to do the same work twice. We have had to coordinate. This is crucial in international criminal law. And we managed it that way, that we did the ones who were present in Germany, and the ICC do the others, like Mr. Muda Chumura, who is still in the DRC, the military leader of FDLR, or others. And we did it in a rather practical way. We saw the necessity to cooperate with the ICC, not to come across with our investigations, with their investigations, and not to make a double work. And this worked pretty good. We established a stable contact on the working level. We know each other, and if necessary, we just write an email or whatever. And this is something what is crucial. All in all, we are very much connected to each other, to the colleagues all over, at least Europe. There's, some of you probably know that, there's the so-called Genocide Network meeting at the Eurojust level. It's an institutional meeting, what takes place twice a year, where all the relevant prosecutors all over Germany, all over Europe are present. In general, well, some countries are not that far in the development, and they send only one person, and sometimes every time another one. A little bit difficult, but others send delegations with colleagues I personally know for years by now, and this is crucial to exchange the information and to know what each war crimes unit in each country does. Yeah, that's from our perspective, it's a very practical approach to meet with each other. And one thing I would just want to mention, we established in my office, we established a second war crimes unit because of the sheer amount of cases. And the first thing we did, my new colleague, leader of the second war crimes unit, and I, was to go to The Hague and to get in contact with OTP, with Judge Schmidt, of course, and with Eurojust. This is what we did in the first week of her new job.
Mm-hmm. Thank you for that. One thing that Christian told me earlier as well, and I want to bring it back briefly to Phakiso before I open it up to all of you. I'm very conscious of time. We have half an hour left. Phakiso, Christian told me earlier that his office has one point person in your division with whom they interact regularly. Maybe you can take that as an opportunity to tell the audience a little bit more about the everyday life of your division, how you, for example, cooperate with states such as Germany that are able or willing, and how you cooperate with those that don't, because obviously that's also part of your job. So maybe in a couple of sentences, give us a sense of what your work is like on a day-to-day basis. Yeah,
just to underscore that cooperation is a two-way street. It's not only the states that are obliged to cooperate with the court, and that the court also, under the provisions of the statute, a state can request information and evidence from the OTP. And that has been done. I think that has been effectively done in the case of Germany and many others where they provide, we can provide information that is in our possession to enable them their own investigations. The day-to-day work on at least in the division, in as far as cooperation is concerned, is really chasing states to cooperate. We have spoken about the need to create offices everywhere, and ideally, in an ideal situation, that could happen, but that's realistically that's not going to happen. States are not going to find offices everywhere in the world. We do have offices in the situation countries that facilitate exactly the type of things that you said. We have offices in every of these situation countries, and we interact with them. But the issue, though, the problem goes beyond that. It goes beyond because the information and the evidence is not only in the situation country. It is also in other countries. And we cannot really, and you never know where it is, and it is very impossible to say that you can establish an office in each and every country where conceivably the evidence will be. Even the regional hubs will not solve that, will not solve that problem. So the really day-to-day work, at least in FISO's cooperation is concerned, is to follow up with the requests that we've made to states. I must stress that there is no we have not experienced a situation of refusal to cooperate. There's no refusal to cooperate. The problem is that now the processes at the national level with countries that we're acting with needs to be streamlined. ICC indeed is not as such we're not a priority for many states, in particular to those that we don't work with on a regular basis. If I go to Germany, if we go to Belgium, if we go to any other countries that we have interaction with, the cooperation is smooth because we know who the people are there, we know them. But if there is evidence somewhere in another third country that we come across, and it will take us ages to get that information. So if I know the federal prosecutor here in Germany, I can be able to say, I have transmitted my request for cooperation through the Ministry of Foreign Affairs or through the Ministry of Justice, who is the channel of communication. Can you please take up on this? And then the federal prosecutor, then, who understands and knows exactly what I mean, can be able to pick up the phone and say, this is what is happening here, particularly because he might be the executing department or executing, or he might know who is the executing. So what we are trying to do now is also now to build up networks of international, of prosecutors, networks of cooperation, networks of prosecutors that we work with, so that they can come together, share experiences, share lessons learned, and so that they can be able to help us in any way that we can. We also have what we call focal points in each of the cooperation focal points in each of the situation countries, but we are now extending that also to other countries outside the situation countries. And what we do now is to bring this cooperation focal points at least once a year to The Hague for them to be able to talk among themselves, to share lessons learned. There are countries where the cooperation is going very well, it has become smooth, but then for them to share lessons learned with others where the cooperation is not working that well, not because they are refusing to cooperate, just because that we are not a priority for them. If I walk into the office of the Prosecutor General in any other country, he will show me a big pile of files like this. That's my priority. I've got to be in court tomorrow morning. I've got to prepare for that case. Yours, I will see when I've got the time for them. So for us to be able to work and have that relationship, and for them to understand the importance of them cooperating and providing us with information, that is quite important. One of the criticisms that is laid against the Office of the Prosecutor is that we take too long to investigate. That can only be slowed down, or that can only be go faster if the states were able to quickly respond to our request for cooperation. They could be able to do that. We would be able to do our work much more quicker and be able to have the turnaround time that we require for us to investigate and prosecute.
Thank you, Phakiso. We do have a distinguished audience here, so Phakiso, also maybe think of what you would like to know from them, how to make your life perhaps a bit easier. I'll give you a chance to ask the question in a moment. But for now, let me open up this panel and allow for questions from the audience. Let me start in the back there, the hand that's reaching very, very high in the middle section there. And I'll take 2 questions at a time for now and direct them to one of the panelists so we get as many questions in as possible. So go ahead.
So thank you. As one of the people who asked Almudena to mention the Pinochet case anniversary and the thousands of domestic cases in South America for dictatorship-era crimes against humanity since, I'm struck by the fact that our natural focus so far over the days seems to have been on the ICC and the situation states as almost as a binary, almost as a closed system. And I think Almudena and Prosecutor Ritscher have added this dimension of third country cases using universal jurisdiction or universal jurisdiction plus, or more traditional forms of jurisdiction where we have regional and trans-regional violations. But I don't think I've heard any mention of the regional human rights systems or the regional human rights conventions. And I think surely if universalism is in trouble and if strong forms of sovereign discretion are unsatisfactory, regionalism, or at least regional human rights dynamics, are key. So, if we are proposing ICC country officers, regional officers, are the Inter-American Commission and Court and their equivalents not obvious partners or interlocutors, or at least other actors in that kind of system who we should be thinking about a little bit more closely?
All right, thank you. So this is a question about, or speaking to the issue of alternative accountability mechanisms. Specifically, the audience member asked whether regional initiatives, whether at a retributive level or perhaps other institutions might be feasible. Let me take one more question here in front.
Erika, sorry, is this on? Okay. Erika de Wets, University of Pretoria and University of Bonn. My question, and it's a comment, and I'll get back to that this afternoon, but it needs to be mentioned here as well, latches onto the issue of regionalism. I get very nervous when I hear people talking about a strong international criminal court that should reach deeper into the states. Look where we are in Africa at the moment and the backlash that we are facing. And Complementarity, however you define it, the International Criminal Court was meant to be a court of last resort. And if we want a future for the International Criminal Court in Africa, we need to strengthen regional mechanisms for international criminal prosecution. I fully take the point that it's incredibly difficult in Africa at the moment to find functioning national jurisdictions. I do not deny that. But the answer cannot be to relocate everything to the international level. It is imperative that we strengthen within the regional economic communities, ECOWAS and such, that we develop those type of units, hybrid models with foreign judges, models such as in Uganda, the International Criminal Chamber, with whatever their deficits are. We must develop that. And we must be more modest. The International Criminal Court can only be one of a mosaic of elements within the African continent, and we must consider alternative mechanisms of dispute resolution. I know they may come across as fraudulent at times, but it's absolutely not realistic to expect that the court can just, tower above all of this. It has a much more modest role in future to play in that region. And finally, I entirely agree with you that we need confidence with the OTP, but if that confidence has been destroyed once by a previous prosecutor, and we will talk about that as part of a problem after the break, do not think you can rebuild that within just a few years. Thank you.
All right, so we have basically two questions that challenge all of us to perhaps let go of the notion that the ICC is sort of first among equals, primus inter pares, but perhaps it is just one of a number of different mechanisms for coming to terms with violent pasts. I've heard this a number of times during the last 2 days. So let me put this question to Almudena and then to Brenda as well. Both questions basically are pushing you to take seriously not just the international and not go back to the local, but perhaps go one step intermediate. Bring regional institutions into it. I know that the next panel will address this question as well, but very briefly, Almudena, Brenda, what do you have to say in response to these two questions?
Should I begin? I'm no expert on complementarity, but I do believe, I've read articles about considering regional bodies as part of including, whether should or not amount to the complementarity limitation or requirement. And I completely agree. I think, I don't have a lot of experience on regional, but I think that they have been decisive in Latin America, in particular in that region, and I think the African Union as well. And I will think that I'm actually a big believer the complementarity that the ICC should even recognize as complementarity universal jurisdiction. So I think that there's room for everything, and I think everything should be functioning. Everything serves a purpose. At the end of the day, even with all of those mechanisms working perfectly, we still probably are not enough to deter human rights abuses or violations of this scope as much as we would like. So I don't think in particular that we disagree at all. Regarding the second comment on the bad prosecutor, yes, I think that the disappointment of one person, particularly a charismatic person, could be big. I don't judge that, but I think that there is something that I wanted to say, and it's not within that context, but perhaps it's my personal opinion, so I'll take it just as that. There's a profound, including myself, a lack of knowledge about how the ICC works in the countries that I am exposed. I think that that's a shame, and I take as much responsibility as a human being as everybody else who believes in this. I think that is, there is confusion. I think it's perceived as something far away, happening in Europe. I'm from Southern Europe, and Southern Europe is really far from Germany and very far from The Hague. So imagine Chile, or imagine, exactly. So, and I've been growing up with that, and it's very much part of, as the exception of Uruguay and Argentina, perhaps, the lack of grasping, understanding, and perceiving it as an ally, the ICC in the region, just to speak about that exclusively, is enormous. And I think it should be a goal to shorten that gap. That's, I guess, what I was trying to convey. Thank you.
Thank you. Brenda, a quick response?
First of all, I'm a big fan of universal jurisdiction, and I find it unfortunate but understandable that states have put so many limitations on the exercise of that jurisdiction. I also believe that when states are emerging from these mass atrocities, they have many packages of needs. Assigning accountability for horrific wrongs done to the people is one of those packages, and there are different ways to approach that accountability. And so I see alternative responses as very appropriate, and that includes regional criminal court responses, many other responses. I think
Such as?
Pardon me?
Many other responses, such as?
Well, for example, Truth and Reconciliation Commissions, such as South Africa decided to embark upon, such as Colombia now is dealing with. So there are various ways to respond. You have to respond in a way that the victims feel that the wrongs done to them have been vindicated in some way. That's important for sustainable peace. International criminal courts are one of those. In terms of those who are states parties to the ICC, by ratifying that statute, you have accepted basically two responses to accountability. The first one, the primary one, is states, in my view, prosecuting international crimes. And secondly, failing to do that, the ICC. I see no reason why you could not have regional courts, and I think that would be a good development.
All right, thank you. We have a question here in front. Do you address your hands?
Thank you. Well, I come from the third world. I come from Latin America. And so I completely agree with this first speaker said about the fact that actually we are a system. Protection of human rights is a system in which every single group counts. So we have the prevention that is given by the states so that crimes do not happen. Then we have the investigation by that state if crimes do not happen. And then if that doesn't happen, we have the regional court in Latin America. And the regional court sees to it that crimes are investigated at the local level by imposing juridically binding sentences upon states, and then the people within the state will use that as an instrument for their internal fights. And if that doesn't happen, you will have the International Court to deal with the individuals, because we deal with the states. But it is a system, so we don't even have to talk about complementarity in the sense of the ICC. We should cooperate in all the different places where there is a possibility to deal with human rights. And I think that has been really missing in the talks that I have heard so far.
Okay, thank you very much. We have one more question here in the last row in the middle. Yep.
Hi, thank you so much, Chair. Jim Goldston, Open Society Justice Initiative. This is a really important discussion, and I think it's understandable given the context that it is, to some extent, the discussion has a Hague focus and an ICC focus. But I think it is important to try to recall and underscore the distinction between complementarity as it needs to be understood by judges who are interpreting the statute to decide whether they can actually go forward with a case or not, and the broader concept of complementarity as most people understand it on the ground, in which the ICC, as most speakers have been saying, is one player among many. And people who are dealing with real life and real problems are looking for solutions to their problems, and the Hague is a long way away, and they're looking for anything that can help. So my organization has worked on these issues for a number of years with governments, for civil society. A couple of points on that. One, I think the ICC has been doing a very good job trying to share its expertise. with local actors to the extent that its time allows, given what its primary mission is, and given what its state sponsors allow, given that some of them are not very enthusiastic about the ICC spending its time on those activities. But whatever the ICC does, I think it's important to recall that the principal drivers or what happens in terms of national accountability are states themselves, are national justice actors, are states who are funding, who are investing political will into these efforts. We have learned that notwithstanding the important efforts to try to build technical capacity, Brenda's suggestion is a very welcome one, I think. Those are necessary, but the critical factor in determining whether national accountability happens is usually politics as much as technical capacity, if not more. And so I think it's just important to keep that question of political will in mind when we're talking about the subject. And then final point, I think it's critical as well to underscore the role of victims groups and civil society organizations who work with them. That has numerous implications in terms of the importance of outreach by any of the institutions, including but not limited to the ICC that we've been talking about, and also in terms of funding by states. Constantly hearing of states saying, I'm torn between, I want to support the IIIM, but then I have to cut funding to civil society. Those choices are hard, but certainly civil society should not be underestimated as an important actor in fulfilling national accountability responsibilities. Thank you.
Mm-hmm. These are two comments rather than questions. I'm just going to leave them in the room, and you can take them up if you see anything you'd like to respond to. Let me just ask, get more questions. Bill Pace is on the list.
Thank you very much. Very, very quickly, one thing I mentioned to the legal advisors in 1995 is that the principle of complementarity actually is a very high-minded principle in physics. It had nothing to do with the way it was introduced in the international humanitarian law context. But the question I have is I think to build upon what Jim Goldston just said, that the political will is often as much the problem as the actual institutions capable of administering ICC crime justice. But that now also exists within our Assembly of State Parties. And where I'm worried, and the reason I made points yesterday, is that I think we need to put as much pressure on the state parties to do, like Germany and others, to really step much more up to the plate with national jurisdictions, with arrest, with cooperation, etc. And the question to Phakiso is, I didn't know where, I understood a little bit where you were, your skepticism about the term complementarity, but I didn't know where that left you at the end. It means a lot to a large body of people in the Rome Statute system at this point, and is it the OTB or your view that it's a mistake, or that we should continue to build upon it? Thank you.
Let me add one more question to the list. Kamari. Here in the front, sorry. I have a long list of questions. I have about 12 people on my list, so I'll try to fit as many in as I can. Please bear with me.
Okay, Kamari Clark, Global and International Studies from Carleton University, as well as the African Court Research Initiative, funded by the Open Society. I wanted to ask a question, primarily to Phakiso, of course, about the temporality of complementarity. And of course, as we know in the African region, the role of commissions of inquiry, the timing of investigations. I think the Kenya example is an example of the problem and failure of, perhaps for good reasons, perhaps not, but the failure of pacing the zest of the past prosecutor. I wonder if you can comment on this temporality issue and whether or not looking forward, and perhaps even looking back, to what extent complementarity, or at least the OTP, should adhere to or think about or consider more passionately how the timing of the release of arrest warrants, etc., could advance and complement the work and cooperation with states, especially in the African region.
All right, thank you. So, Phakiso, we have basically two questions I'm going to give to you. Bill Pace's question, why are you skeptical? Where does it leave you, the current state of complementarity? And then Kamari's question, which you just heard. So if you just...
Bill, I'm sorry if I expressed any skepticism about complementarity. I've got no comments about complementarity at all. My issue is that now states don't seem to understand what complementarity is and how it should work. And that is where we need to focus our attention. As I said, there have been many efforts that have been done to try and make complementarity work and to have complementarity work. David can attest to that. He tried with his green tree. You were part of that green tree. What happened to green tree? The EU complementarity toolkit that was developed now to try and see exactly for states to see how complementarity can work in practice. That I don't know also where it ends. So it's not my skepticism about complementarity. It's a good concept, it can work, but it's just that states need to take concrete actions to make complementarity work. One of the problems that we face, at least as the Office of the Prosecutor, in what we promote as the so-called positive complementarity, when we try to encourage states themselves to investigate and prosecute so that we don't have to come in. Two problems. We don't have the capacity to do that. ICC, can you help us? No, states have told us, ICC, you are not a training institution. It is not your mandate to investigate and prosecute. So that is where, again, now institutions like the Academy can come in to try and build that capacity at the national level for the national judicial systems to be able to take up these jobs. Secondly, funding. We don't have the funds to do this. Again, states have told us, you're not a funding institution, ICC. Focus on your mandate. So these are the issues that we need to be looking at now to see exactly now how we can address them. Because these are the demands that were being made on us as OTP, much as we try anywhere, whether it be Guinea, whether it be anywhere else, when we say states, can you please take up this claim? Because can you prevent the ICC from intervening? Because you can do it yourself. We believe that you may have, even sometimes where there's willingness. I understand that there's political willingness can be a factor in most cases, but sometimes, like Guinea, for example, there seemed at least they are building up of willingness for the Guineans to do to investigate the crimes there. But they've complained about lack of capacity as well as lack of funding. Kamara, as you know, the the international crimes don't prescribe. They don't prescribe, so they can wait. They can be done anytime. The one thing that I should also stress is that the ICC, or at least the Office of the Prosecutor, has never claimed monopoly of justice. It is what is not acceptable is that these crimes should go unpunished, and that perpetrators should perpetrators should go unpunished. So again, this is where the negotiations and the discussions between the court and states should take place. Exactly, we should be able to know what is the state doing in respect of this now. What is it that can be done? This is and sometimes that is why the office is being criticized for taking long in preliminary examinations. Take Colombia, for example, where we've been there for quite long. We are there for a quite long time because Colombia is taking the necessary steps for it to investigate and prosecute these crimes. And it is also an example where a peace process as well as justice mechanism can go hand in hand, they can go together. So this is really opens calls for a need for a dialogue with states to see exactly what the ICC is doing, to see what also the prosecutor is doing, and to see what the state is doing, so that we can both be able to work together to see that at the end of the day, as we said, the primary responsibility rests with the state. And if the state is genuinely committed to investigating and prosecuting, then there will be nothing that is going to be done. Just one final point now on the regional mechanism. The statute foresees complementarity between the ICC or the OTP and national judicial systems. Well, my personal view, I don't know what the judges might say when this comes to them. I don't think that the judges will throw out a case if it is being genuinely investigated and prosecuted at the national level, despite the fact that there's nothing in the statute to say that there's complementarity between national judicial systems and between ICC and regional organizations. If the proposed African court were to investigate cases, if they were to create them, we as the OTP would recognize that in terms of admissibility. We recognize that in terms of admissibility, and if the challenge was to be made to the court, then it depends on what the judges would say, but I don't think that would stand in a way of a genuine investigation and prosecution by a regional or by any competent court that has got jurisdiction over the matter.
All right, a very diplomatic response. We are running out of time. I'm going to collect 3 more questions. David is next on my list, and I'm going to put them to the panelists. Again, I'm trying to get everybody in, but there's so much interest. I can't accommodate everyone. I apologize for that. It's a function of time. I'll gather these questions, and I will give each of you a minute or so to respond to either them or anything else that caught your attention. And then I would encourage you to continue the debate over lunch as well. David is next.
Thanks very much. Can you hear me?
Yes.
Okay. And a number of things have already been said that I would strongly agree with, and I'm very glad that Brenda raised truth commissions and other accountability processes, which I think need to be held in the fore. What I did want to respond to, Phakiso, is of course our many discussions at Green Tree and elsewhere. What I took from those discussions, and there were 6 different discussions for Green Tree and 2 in country, Côte d'Ivoire and DRC. And I thought a lot of progress, it wasn't toward defining complementarity, it was really the fight against impunity and how it's carried out on the local level. That's how we conceived it, and that's what we were pushing for. We actually reached a pretty good understanding, I think, of what needed to be done, and we had a tentative commitment from states, but ultimately the development agencies would not commit. So interesting that we got a lot of commitment politically from states to support domestic prosecutions, much of it based on the experience that we had in the former Yugoslavia, which we're setting up the Bosnia State Court and so forth, where you did have a lot of domestic prosecutions. And that was sort of the model, but where we ran aground, we reached a point where we thought we had a group of core supporters, 4 or 5 key states. But when they go back to capital, then it melts like snow in the sun. And this was really the essential issue. And we tried to get the World Bank and other development agencies to come to the fore. They didn't want to do it. They would not even officially appear because ultimately this would undermine other projects of theirs. So I think that complementarity is a fairly clear concept in my mind at least, but getting the material support is very, very difficult when development agencies want to build schools and roads. They see accountability efforts, I think quite wrongly, but they see this as undermining their development, World Bank and so forth, undermining their work on the ground. And that conversation really needs to be much stronger if you're going to have domestic prosecutions and to some extent other accountability mechanisms. And we've not had that. And it'd be interesting to have another closed doors discussion now this many years on with those actors, because ultimately if you don't have their funding, you're not going to be able to have domestic prosecutions, because ultimately you can't do it without their support. So that, I think, ended up to be the lesson of Green Tree, unfortunately. And I wish we'd had a more positive result. Thanks.
All right. 2 more questions I'll add on. There was one in the very back on the right-hand side.
He's so excited. I'm so sorry. He was so...
Thank you very much, Mr. Chairman. And thank you to the panel. Mohamed Bangura, Residual Special Court for Sierra Leone. Part of what I intended to ask has been addressed, but it has to do with capacity of states. When it comes to complementarity, we've heard already about the difficulty with states to be able to play their own part in addressing crimes, and so, in effect, complementarity comes into play. But what I would like to hear more from the panel is the issues that limit states' capacity to play their part in addressing the crimes. We have heard from Brenda that, in fact, there are as many as perhaps 50 states or so that haven't, they haven't domesticated the Rome Statute. Now, what are the problems? Of course, there's normative capacity, which is the inability to actually get the statutes completely in a domestic setting. But what other factors are there? Institutional capacity, for instance, and those have not been addressed in my view. What does the panel think? We also had, for instance, yesterday from Hans Korel, and he mentioned the fact that he was dismayed with the way the court dealt with the case of Libya. It was sent back to Libya, to a domestic jurisdiction. That had to do with the court's interpretation of the unable or unwillingness to try cases. So what does the court, when the court interprets cases, interprets these principles in this way, how does that affect complementarity? Does the exercise of complementarity have its effect as we expect it when, in fact, in this case, it was more or less a reversal of the principle, where, in fact, we expected that the court takes...
Terrific. If I could stop you there, I think the panel sort of got the gist of what you were wanting it to address. One last question, Richard Dicker, and then I'll give each of you a minute to respond.
Absolutely agree with comments made by most of the panelists and some from the audience about the ICC is not the only actor on the scene, and that criminal trials, as central as they are not the only tool in the toolkit. I also think discussion about these different instruments, including the kind of work that Christian Richter does, that Almudena was talking about, along with the investigative mechanisms that have been created, how to meld those together as effectively as possible in a strategy for accountability is a huge strategic question we need to address. And I would say politely to Klaus and Vivian, you may want to put that on the radar screen in terms of issues you take up. But my question for both Brenda and Phakiso comes from looking at the ICC's experience regarding national prosecutions, because it is the ICC that we are here to discuss principally. And the question is, we have looked closely in 4 country situations of preliminary examination. And what I'm interested in knowing is, from Phakiso, what are the lessons the office draws in terms of where it has been the most effective, whether it be in Guinea, whether it be in Colombia, in pressing for genuine national efforts? What do you draw from that experience? And Brenda, I would like to ask you what you think could be added in the OTP's toolkit to be even more effective in pressing for national prosecutions. And I ask this in light of points that David Tolbert just made and Jim Goldston made earlier. Thank you.
All right, terrific. I'm going to give each of you 1 minute. Please just pick one question or one aspect of the question to address. Don't try to be exhaustive. I start in reverse order with Christian.
Thank you. Thank you very much for these comments and questions. Of course, Phakiso is completely right with what he said concerning complementarity. From my point of view as a third-party state, well, it's a different kind of complementarity as a crime scenery has in a state where the crimes happened. So what I always say is that in order to make the impunity gap even smaller, it is crucial to cooperate anyway with the ICC and to share information with the ICC or the other way around. It's always of use for both sides to cooperate. And to keep in mind that maybe yes, the ICC is the tribunal of the last resort, and national prosecutorial agencies may be in the first row. Anyway, it is I think you cannot certainly. Yeah, you may have to to be a prophet if you know if what you change and if you know if the information which you change will be useful or not at the end of the day, and therefore the cooperation and the exchange of information for me seems to be crucial even for further generations in the courts and in the prosecutorial agencies.
Thank you, Christian. Almudena, 1 minute.
Okay, maybe less, I'll take less. I'm going to just echo what Jim was saying and what Ritscher, if you allow me, just from my own, because I do come from that civil society. I'm a lawyer in that spectrum that has attempted to use whatever the mechanisms outside of, obviously, official institutions were available to seek redress or to represent victims. And then I echo Ritscher, because perhaps that's what the intention will be, or definitely is what is in my heart, even if I didn't express it, is that there are all these things out there. When it comes to individual liability, which is an aspect also versus regional mechanisms that we haven't talked about, is the regional mechanisms usually go against the states. I think the challenges are slightly different when you are trying to establish individual liability, but I agree that the bottom line is there's all these things out there that I wonder when we have done it from civil society, it's lengthy, so presents a lot of the problems. It's lengthy, it's complicated, there's a lot of lack of resources, there's lack of political will, and despite of that, some of these efforts have been quite effective. So I wonder how much of that experience can be extrapolated, exchanged, and maybe be useful for the International Criminal Court. I would love to see that in the future years.
All right, thank you, Almudena. Brenda, 1 minute.
Capacity building. I think that inherent in the Rome Statute is the requirement to assist states to have the capacity to do what they are obligated to do under the statute. However, I don't see that as a court responsibility. The court is busy with its judicial mandate. The ASP is responsible for partnering with training organizations to meet what I think is an inherent responsibility of the statute. OTP toolkit, I think more personal interaction between experts from the OTP and the relevant authorities in the country. So investigators with police, prosecutors with prosecutors. But again, I think we need to look to the ASP to put pressure on member states who are not fulfilling their obligations to do so.
All right, thank you. Phakiso?
Yeah, I couldn't agree more with Brendan, and I think this goes to your point, David, that I was not criticizing Green Tree. Green Tree itself was a success in terms of fomenting understanding of but the problem now is now going forward in terms of implementation. That's where the problem is. So again, it is the role of states, it's not and if those states that understood and the EU in particular. And there are many other programs that they did. They didn't have to be a specific program on complementarity. Most of the EU states, they've got support for the rule of law programs in the countries, and that could be injected there to see exactly how they could do that now. Richard, your point about where we think that we've been successful, I wish I could have more positive news on that as well, because now, I mean, there isn't much really that to be said in terms of complementarity in action. Colombia, maybe, the establishment of the special jurisdiction for peace, and the way that it is taking now forward the issues like that we addressed with them, like the issues of the false positives, which is an issue. At least now the special peace for justice seems to be looking into that, but the results are yet to be seen. Guinea, we have spoken about this, and there seems to be political will there. At least now there seems to be investigations seems to have been completed, and they are going to be able to proceed when we don't know. And the other side, flip side of complementarity, where OTP is focusing on those who bear the greatest responsibility and leaving it to the national judicial systems to do the rest. Perhaps Uganda, the ICD, could be an example there where it is, although there's still much to do. One potential in the future is Central African Republic. The establishment of the court in Central African Republic. Again, that might be another point where complementarity, in the other way that we see it, where OTP focuses on those who bear the greatest responsibility, and the local mechanism focuses on all the others because OTP cannot do anything. So there are potentials there, but there just needs to be a push for actually complementarity to have worked in any practical way in any situation country. Thank you.
Terrific, Phakiso, thank you. We've only scratched the surface of the discussion about jurisdiction and complementarity, as you can tell. Not everybody did get to ask a question, but I think the last statement in particular allows us to continue the conversation over lunch. I won't keep you from lunch with any lengthy summary, except to say that I think the one thing the panelists, and I think most members of the audience agreed upon, is perhaps the importance of collaborating institutionally for the ICC with other mechanisms, be there domestic prosecutors, be there regional courts. That's something to talk about more. And perhaps the second thing that I took away from this conversation is, and I'm glad that Brenda brought us back to the Assembly of States Parties, which we talked about yesterday, and I think we'll talk about much during the next panel. And perhaps the importance also to reconsider or sort of to go beyond the enthusiasm that we had for international criminal justice in The Hague, and to recognize now the ICC perhaps is not primus inter pares, but perhaps ought to be considered as just one mechanism for coming to terms with the past and not the most important mechanism. And I think there was a fair amount of agreement in the room on this issue as well. On that note, please join me in thanking the panelists for a wonderful panel.